As you recall, yesterday, Alicia and Stephen spoke to Intellidex Chairman Stuart Theobald about IT billionaire Mark Shuttleworth's historic victory against the Reserve Bank over 250 million rand exit tax slapped on him when taking funds abroad.
Well, now the Sergeant Treasury are considering an appeal. We asked Beric Croome, tax director at ENS, whether Shuttleworth's victory has opened a Pandora's box for governments and the SARB.
I don't think the case is over, because I think we must take note of the fact that the matter went to the Constitutional Court. It was stayed at that level, awaiting this decision. The court yesterday found that the levy was unlawful, effectively in the breach of the Constitution, particularly regarding imposition of taxes. And as a matter of course, that has to be ratified by the Constitutional Court. So it has to go back to that court. I think that the reasoning of the unanimous decision of the court is sound, and I'd like to think the Constitutional Court will endorse this decision, but it remains to be seen if that happens. The judgment referred to sort of not opening the floodgates because Mr. Shuttleworth paid these levies in 2009. The requirement to pay the levy on immigration was removed by way of a circular by the Reserve Bank in November 2010. So it's not an ongoing problem. The issue that arises, though, the judgment refers to the fact that 2.9 billion rand of levies have been collected in this form. Because up until the time the levy was removed, if you wish to immigrate, you couldn't just take all your funds out. You could take, I think at that stage, 750,000, and anything in excess of that, if you wish to repatriate the funds abroad, you had to pay the 10%. Now the question arises, is those other people who didn't pay under protest, because Shuttleworth in this case made it clear that he laid the groundwork for this by paying the levy of 250 million, objecting to it, saying I'm paying this but under protest, giving him the legal basis on which to prosecute the case.
Sorry, if I can just jump in again. So if you don't pay under protest, then you would have no recourse, because then it would be accepted that you paid and that was that.
I was discussing that with colleagues in my firm over lunch in anticipation of this discussion. Because I'm more in the tax area, I'm not involved directly in litigation, but it raises an interesting point because at the time people believed they were paying this levy in accordance with the regulation gazetted by the Reserve Bank or the Ministry of Finance for the Reserve Bank. So they paid it as they were compelled to, because if they wanted to take the money out, they had to pay the levy, and they chose to do so. Now the court turns around and says, actually that levy was unlawful. It was a tax which was in contravention of the Constitution, which has got very strict rules on how taxes are introduced into the country through the budget process, money bills which have a separate process through Parliament, with the Minister of Finance, etc. This didn't follow that. So the question that arises now is, on the face of it, those levies that were paid would on the face of it seem to be unlawful. And you only become aware of that as a result of this decision. Because there's two things. If you didn't pay under protest, can you challenge? And then also the question comes up is as to prescription or finality. How far back can you go? Because normal claims between a debtor and creditor under the Prescription Act expire after 3 years. There are separate rules for monies due to the state, which maybe works one way. General debts due to the state expire only after 30 years. Where you have a tax debt that has been reduced now under the Tax Administration Act to 15 years. What is the position though where it's the other way around, where the state is indebted to a person, a citizen?
Well, you can catch that full interview on